This is Legal Malpractice Part 2. In this lecture, we're going to continue our discussion of legal malpractice, but here we're going to focus on some common defenses that lawyers raise to avoid malpractice liability and some basics about legal malpractice insurance. In other words, there are kind of two sides to how lawyers protect themselves. They may raise a defense to say I shouldn't be held liable at all, or they may have insured against the risk of liability by purchasing malpractice insurance ahead of time. Let's talk about common defenses to legal malpractice first. A lawyer, suppose, may have reasonably believed that a certain action was required by law or an ethics rule, a legal ethics rule. By reasonable, we mean it just like in your torts class. This is an objective standard of what most competent, diligent lawyers would have thought in the situation. So if they can say, I had no choice, I was ordered to do this, or there's a statute requiring this, then that would be an adequate defense most of the time. Also, the client's comparative or contributory negligence. So for example, some clients are very uncooperative about discovery and production. They refuse to turn over things like their personal tax returns or birth certificates and marriage certificates. And of course, lawyers also know that a client who refuses to cooperate with normal discovery requests will face consequences. That could be in the form of court sanctions or default judgment or maybe a waiver of certain claims. But some clients are really stubborn and recalcitrant, and that's not entirely the lawyer's fault. It may not be the lawyer's fault at all, but we may consider that in how much fault we assign to the lawyer. Other clients are just extremely stubborn or spiteful, and they refuse to accept even a generous settlement offer from the other side. Some clients do this repeatedly. And some clients suddenly become unavailable or unreachable on the eve of trial, maybe without explanation. And then when things go badly, they sue their lawyer for malpractice. But the lawyer can point out ways in which the loss was either entirely or at least in part the client's own fault. Next is a client's assumption of risk or failure to mitigate. So an example would be if a client was clearly warned up front that they might be responsible for the prevailing parties, the other side's legal costs if they lose. And they insisted on going forward with a trial even though it was risky. Well, in that case, they've assumed that risk. And similarly, some clients could have taken measures to mitigate their losses from the lawyer's misconduct or negligence, but they just chose not to. And that is not really the lawyer's fault. And it may be a partial defense to liability, at least for some of the client's losses anyways. Now, let's talk about the statute of limitations in legal malpractice cases. On the one hand, our starting point is usually whatever the statute of limitations is in that jurisdiction for negligence tort claims. Sometimes there's a statute specifically about professional malpractice that applies to doctors and lawyers and accountants. But I must warn you, the statute of limitations can become very complicated with legal malpractice. So first, it doesn't run on a client's claim while the lawyer continues to represent the client. So if your representation is ongoing, you continue to represent the client for several years, the statute of limitations doesn't start running until that's done. It also doesn't start to run until the alleged malpractice significantly injures the plaintiff. And it does not start to run until the lawyer discloses the malpractice to the client, or the client becomes aware of it, or at least reasonably should know that the malpractice occurred. What this means in practice is that some legal malpractice cases are brought many years after the representation ends, because it takes a long time, let's say, for the client to discover or realize that their previous lawyer made a mistake. Or maybe it takes a long time for the mistake to have an effect. I'm going to give a quick example. Let's say that you draft a will for a client. Well, sometimes when you draft a will for a client, they live for another 10 or 20 years before they pass. And very often it's not until the person passes that it's discovered that the lawyer didn't do the will properly and it's declared void, or it's subject easily to challenge by other people who are disinherited. and so forth. So we could be having litigation about the lawyer's negligence in drafting a will brought by, let's say, the executor of the estate or some of the heirs who would have inherited if there was a valid will, but that could occur decades after the will was actually drafted. Let me tell you about a case that I encountered myself in practice. There was a small rural church that had started. It was a new congregation. It was actually the first congregation for that denomination in this respective state. And they hired a small town lawyer to handle their incorporation and the establishment of their tax exemption, and to help it purchase a large tract of land on which they built their sanctuary and a small parsonage where the clergy could stay. But this lawyer did not know what he was doing. He had never set up a church before, and he made several huge mistakes. And none of these rural church members had any idea about this, but their land and building were not exempt from local property taxes because the lawyer had never filed the proper forms to secure a property tax exemption. The church leaders just assumed that they were exempt, and so they never paid any property taxes. And then after 12 or 15 years, suddenly the town demanded a huge sum all at once for unpaid back taxes from all those years. And it was more than the church could afford. It was at this point that I was actually brought into the case, and that I handled pro bono as a new lawyer to try to help the church. And I discovered as I reviewed what happened, the original lawyer's mistakes. So by that point, it was more than a decade before the church entity had realized that their original lawyer had committed malpractice, or before they even knew how much loss they would suffer as a result. And this creates a really difficult situation for all lawyers, especially with transactional work like contracts or drafting wills or doing the legal work for the startup of a new entity. It can take years for the problem to emerge. And very often by then, the lawyer has moved on to another firm, maybe has even retired from law practice or is no longer in the jurisdiction. This makes insurance issues particularly complicated, much more complicated than, say, a typical accident case, where we often know up front the extent of the victim's physical injuries or the extent of the property damage involved, even before the case is filed. With legal malpractice, a mistake you made when you were a new lawyer can come back to haunt you decades later, seemingly out of the blue. Let's talk about the liability for the law firm itself. A law firm can be civilly liable for injuries caused by an employee or a principal of the firm who was acting in the ordinary course of the firm's business, or with actual or apparent authority. Now, that's not too surprising, and plaintiffs will usually sue both the firm and the lawyer individually. This can get complicated, as you might imagine, if the firm has merged with another law firm in the meantime, or has switched its insurance carrier in the years in between. Law firms are organized different ways. If the law firm is organized as a partnership without limited liability, each partner could be jointly and severally liable with the firm. In other words, vicarious liability for every partner. Also, don't assume that discussions between lawyers within the firm about potential malpractice will be privileged. Often they're not. Let's continue talking about the firms. A lot of firms are limited liability firms, like LLCs or LLPs. And in that case, a firm remains vicariously liable for injuries caused by an employee or principal, but the principals of the firm are not personally liable for actions in which they did not participate personally as supervisors. This may sound like a mind-numbingly boring point, but it's actually been tested on the MPRE. Now let's talk a little bit about malpractice insurance. I've already mentioned some reasons that this gets very complicated. Malpractice claims often come many years, even decades, after the representation ends. And by then, many lawyers have changed firms or retired, and firms have merged or switched insurance providers. And malpractice insurers themselves may have merged with other companies or have gone out of business. One important point to keep in mind is that the ABA model rules do not require lawyers to even carry malpractice insurance. In fact, at the time I'm recording this lecture, and this has been true for a long time, only one state requires lawyers to carry malpractice insurance, and that's Oregon. But about half the states require lawyers to disclose upfront to clients whether they carry malpractice insurance. So it would be a required disclosure before the representation begins if you are uninsured. In practice, a lot of sole practitioners or little two-lawyer law firms do not have malpractice insurance, but most or all of the big national law firms do. And as with other areas of tort law, a lot of individual sole practitioners are essentially judgment-proof, while the big law firms have a lot of assets and therefore a lot to lose. If you watch that lawyer show called Better Call Saul, there are some episodes in one of the seasons where the main character, who is an unsuccessful sole practitioner, has his license suspended for a while. And as a result, he loses his malpractice insurance. And then that sets off a series of other important plot developments that I won't ruin the plot for you. But in real life, to be honest, a lawyer like that would almost never have had malpractice insurance in the first place, outside of the state of Oregon. Policies vary. Some may have high deductibles or caps on coverage and things like that. Basically, you get what you pay for, just like with other types of insurance. If you've bought car insurance, for example, you know the difference between a simple liability policy with a high deductible or comprehensive collision insurance and so forth. Now, there are two general types of liability insurance you should be aware of, and here we're going to learn a couple of new vocabulary words. The first is called occurrence policies, and these used to be the most common. These covered lawyers for acts or omissions during the policy term, regardless of when the claim was asserted. So if you were covered, let's say during the 1990s, and even though you stopped paying on the policy, if you were later sued for malpractice in the 90s, that policy would cover it. The modern and more common form of insurance now is called claims-made policies. These cover the lawyer for unforeseen claims made during the policy period, no matter when the incident occurred. So if you have one of these policies and you get sued, it could cover things from before, although a lot of them will not cover pre-existing liabilities. If the lawyer has changed jobs or changed insurers, she may need supplemental, what we call prior acts coverage, to prevent gaps in the policy applicability. And we often call this tail insurance. That's our last term you kind of need to know. Lawyers who change firms or who retire often need to get tail insurance policy to cover gaps in their other insurance coverage that result from a previous firm switching insurance carriers or simply canceling their insurance policy. This concludes my discussion of malpractice liability and insurance. I'm going to include in my course materials a link to a short animated video that the American Bar Association made about the importance of tail insurance, which I recommend students watch after this.